This is the silence they said would never come. For 8 years, Donald Trump lived in a legal reality where normal rules were bent. Indictments turned into campaign rallies. Legal decisions vanished in appeals. Prosecutors hesitated. Judges delayed. The system seemed to contain an invisible exemption clause written just for him. But this morning, that exemption evaporated. At exactly 10:07 a.m. Eastern Time, the United States Supreme Court issued a decision so rare, so unanimous, so surgically precise that even the justices who owe their seats to Trump signed on. 9 justices, 0 dissent, 1 target. The Trump Organization is not being fined. It is not being audited. It is being dissolved. And what has happened in the 11 hours since this ruling was announced has not been covered by the mainstream media because they are preoccupied with the headline. They miss the earthquake beneath it. Breaking news from Washington, D.C. has shaken the global financial system, the Republican Party, and the American presidency itself. The Supreme Court just issued an order for the immediate and complete dissolution of the Trump Organization. This is not a stop order. This is not a fitness review. This is corporate execution. As we speak, court-appointed receivers are being assigned to every Trump entity. Bank accounts are being frozen. Asset inventories are being taken. Lease agreements are being reviewed for transfer. An empire built over 5 or 10 years is being dismantled in real time. The reason? Systematic fraud, intentional deception, institutional abuse baked into the operational DNA of the organization. But here's what makes this different. The court didn't just rule on one case. They wrote a legal framework that could be applied to any corporate structure accused of systematic deception. They created a weapon. And the timing of this decision, exactly 283 days before the 2026 midterm elections, in the midst of a global financial crisis, as Trump's legal troubles accelerate on multiple fronts, is no coincidence. This is a controlled explosion, and the blast radius is set to spread far beyond one man's real estate portfolio. To understand why this decision represents a seismic break from American legal tradition, we need to understand the assumption that has governed executive power for generations. For over 2 centuries, there has been an unwritten rule in American politics. You don't go after a president's private wealth. You don't target his businesses. You don't liquidate his assets. Not because of the law, but because of precedent, etiquette, and the fear of destabilizing the office itself. Even Richard Nixon, facing impeachment and criminal investigation, was never threatened with seizure of his personal assets. Bill Clinton, legally sued while in the Oval Office, faced subpoenas, but never had his assets seized. The legal system operated on the principle that the presidency must be protected from financial warfare. Trump acted under the same assumption. He believed that his status as a former president and potential future candidate would create a legal shield, that prosecutors would hesitate, that judges would delay, that the Supreme Court, especially his Supreme Court, would provide protection. For years, this assumption held true. The New York legal fraud case dragged on. Appeals bought time. Surety companies stepped in. Seizure orders were delayed. But something changed. The financial collapse in Tokyo, contagion in the bond market, the collapse of Trump's appeal bond. Suddenly, the legal dam holding back enforcement cracked. And this morning, the Supreme Court didn't just let the water through. It opened the floodgates. The message is clear. The system will no longer exempt political figures from the full force of civil law, not because of politics, because of survival. The court is signaling that institutional credibility is more important than individual power, and this is the paradigm shift that no one saw coming. Let's examine the legal mechanism the court just activated, because this is where the decision becomes a blueprint for future cases. The case stems from the New York Attorney General's investigation into legal fraud. The allegations were clear. The Trump Organization systematically inflated asset values to secure favorable loans, then deflated those same assets to reduce tax liabilities. Same properties, same time periods, wildly different valuations depending on the audience. For example, according to court filings, Trump Tower was valued at $327 million when presented to lenders in 2015. That same year, it was valued at $117 million for tax purposes. That's a 179% discrepancy for the same building in the same fiscal year. Apply this pattern to dozens of properties and 2 decades, and you get what the court called a systematic fraud architecture. This is where legal theory becomes critical. Normally, legal fraud cases result in fines, sanctions, and oversight. You pay the damages, you appoint a compliance officer, you move on. But the Supreme Court decision referenced a provision rarely used in New York corporate law: dissolution for irreparable abuse. This statute allows a court to completely dissolve a company if the abuse is so widespread, so embedded in the structure, that no monetary penalty or reform can fix it. It's corporate death penalty. And the standard set by the court is chilling. If a corporation's business model relies on systematic misrepresentation and that misrepresentation creates an unfair competitive advantage, the corporation can be dissolved. Not reformed, dissolved. Here's what makes this a precedent bomb. The ruling explicitly states that this standard applies to any corporate structure where fraud is operational, not accidental. This language doesn't just target Trump. It targets any organization, political action committee, dark money network, or shell company accused of institutionalized deception. The court has equipped prosecutors nationwide with a tool that could dismantle entire corporate empires. And Wall Street took notice immediately. According to Bloomberg, within 90 minutes of the ruling, major law firms began sending internal memos to high-risk regulatory clients. The message was simple. If your business model relies on creative accounting, aggressive valuations, or jurisdictional arbitrage, you are now at risk. This is no longer a Trump issue. It is a systemic recalibration of corporate accountability. So what happens when the court-appointed receiver walks into Trump Tower tomorrow morning? Immediate asset freeze. Every bank account linked to the Trump organization is frozen. JP Morgan Chase, Wells Fargo, Deutsche Bank receive court orders to freeze withdrawals and redirect balances to a receivership account. This is not a gradual process. It happens overnight. If payroll is scheduled for Tuesday, it won't happen. Employees from executives to janitors won't get paid. Vendors won't get paid. Contractors will halt work. This is how you kill a company in 48 hours. Rent and contract termination. The Trump organization doesn't directly own most of its properties. It operates through ground leases, licensing agreements, and management contracts. 40 Wall Street, ground lease. Trump International Hotel, management contract. Trump Tower commercial spaces, mixed-use property with lease dependencies. When a company is terminated, these agreements can become void. Landlords can repossess the properties. Licensors can revoke brand rights. The Trump name can be removed from buildings while Trump is still alive. Picture it. Workers on scaffolding, removing the gold letters from Trump Tower. This is not speculation. It is the legal consequence of dissolution. Lender panic and accelerated foreclosures. According to financial disclosures analyzed by Forbes, Trump has an estimated $1.1 billion in unpaid commercial debt. This debt is now secured by properties under receivership. Almost every commercial loan contains a material adverse change clause. If the borrower's corporate structure is dissolved by court order, this triggers default. Lenders don't wait. They call in the loans. They demand immediate repayment. If the borrower can't pay, they foreclose. So the receivership is trying to sell assets to pay. Banks try to seize assets to recover their loans. It becomes a feeding frenzy. The asset is torn apart by competing claims. And in a distressed market, fire sales destroy value. A property worth $200 million under normal conditions might sell for $80 million in a forced liquidation. Trump loses the asset. The judgment is not paid in full. Banks suffer. Everyone bleeds. Political collapse. Trump's political brand is built on an image of success, wealth, power, the winning man. If his business empire is being liquidated in real time, that image collapses. Campaign donors see weakness. Voters see failure. Rivals see blood in the water. The Republican Party, already divided over Trump's legal troubles, now faces an impossible choice. Do they defend a candidate whose businesses are being dissolved by the Supreme Court? Or do they cut ties and risk an internal war with the MAGA base? This ruling forces that choice. And now, months before the midterms, it forces it. Constitutional crisis trigger if Trump doesn't comply. if he orders his staff to resist the receiver, if he uses his political influence to block enforcement, we enter uncharted territory. You cannot enforce a Supreme Court order against a former president without federal marshals. And if marshals show up at Trump Tower, it becomes an optical constitutional nightmare. This isn't just a domino toppling a business. This is a domino toppling the system's ability to function without force. For Donald Trump, this is not a legal defeat. It is an existential assassination. Trump does not view his buildings as investments. He views them as extensions of himself. His name, written in gold letters on the skyline, is proof of his existence. His wealth is his identity. His brand is his soul. Dismantling the Trump Organization is erasing Donald Trump. Sources close to Trump speaking anonymously because they are not authorized to discuss private conversations describe his reaction to the ruling as beyond anger. One aide used the word catatonic. Another said he was silent for 20 minutes after reading the ruling, staring at the opinion without speaking. This silence is more frightening than any outburst because Trump's entire life has been defined by his ability to retaliate, to sue, to appeal, to negotiate, to bully. But when the Supreme Court rules 9-0, there is no appeal. There is no negotiation. There is only compliance or contempt. And for a man who has never voluntarily surrendered anything in his life, this choice is paralysis. Imagine waking up every morning at Trump Tower knowing that a bureaucrat appointed by the court now controls the work of your life, that your employees answer to them, not you, that your bank accounts are frozen, that your properties are being inventoried for sale. On paper, you're a billionaire, but you can't spend a dollar without permission. This psychological torture is worse than prison for someone like Trump, because prison has an end date. Termination is permanent. Reports show Trump has been on the phone with his legal team for hours, demanding options that don't exist. He wants emergency stays. He wants the Supreme Court to reconsider. He wants congressional intervention. But his lawyers are telling him what he doesn't want to hear. The game is over. The court has spoken. Now, the only question is whether he will go quietly or defiantly. And in this case, defiance leads to criminal contempt, which leads to jail. So we are watching a man who has spent his life avoiding consequences finally collide with a consequence he cannot avoid. The tragedy is not that he has to answer for his actions. The tragedy is that he built his entire identity on a lie he will never give up. What does Xi Jinping think when he sees the Supreme Court dismantling a former American president's business empire? He sees weakness. He sees chaos. He sees a system that cannibalizes its own leaders. In authoritarian frameworks, power is absolute and permanent. The idea that a judicial body could strip a leader of his wealth even after he has left office is incomprehensible. It signals instability, and instability invites aggression. China is currently increasing pressure on Taiwan. According to intelligence assessments reported by Reuters, the People's Liberation Army has increased naval exercises in the Taiwan Strait by 340% in the last 6 months. They are testing American resolve. If the United States is distracted by internal legal battles, if its political system is paralyzed by constitutional crises, if its former president is fighting for financial survival, this creates a window for Beijing to act. The same logic applies to Moscow. Putin has been betting for years that American democracy would collapse under its own contradictions. The Supreme Court ruling, in his view, proves he was right. If Trump, once the figure commanding the presidency, can be legally destroyed by his own system, what does that say about the resilience of American power? It says that American institutions devour their own people, and that makes them predictable. It makes them exploitable. European allies watch this with a different kind of concern. They depend on American stability for security guarantees. If the U.S. political system is consumed by internal purges, how reliable is NATO? How credible are defense commitments? The impeachment decision sends the message that the rule of law is working, but it also sends the message that American politics is a blood sport, and allies don't want to be dependent on a system that may be too preoccupied with defending itself. The geopolitical cost of this decision is not immediate. It is cumulative. Every enemy sees the chaos. Every ally sees the risk. And over time, this perception erodes power projection. If America cannot stabilize its own leadership class, how can it stabilize the world? So how does this end? Scenario 1, full compliance and quiet liquidation. Trump's legal team advises him to cooperate fully with the receiver. Assets are sold in an orderly process. The decision is carried out. Trump retains some residual wealth from properties outside New York jurisdiction. He exits politics. He fades into obscurity at Mar-a-Lago. The Republican Party moves forward. Probability, 15%. Trump has never voluntarily surrendered anything in his life. Compliance would require a psychological transformation that seems impossible at this stage. Scenario 2, legal guerrilla warfare. Trump files urgent motions in every available jurisdiction. He seeks stays, injunctions, and procedural delays. He turns the dissolution into a multi-year legal battle. Assets remain in limbo. The political optics become toxic. The 2026 midterms become a referendum on whether the courts are being weaponized. Probability, 60%. This is the most fitting response for Trump. Fight until there is nothing left to fight for. Scenario 3, open defiance and constitutional crisis. Trump refuses to cooperate. He orders his staff to resist the trustees. He uses his political network to block enforcement. Federal marshals arrive at Trump properties. Images of law enforcement enforcing Supreme Court orders against a former president dominate the news cycle. Trump declares the judiciary illegitimate. His supporters mobilize. The system breaks down. Probability, 25%. This is a nightmare scenario. It requires Trump to be willing to risk criminal contempt and potential imprisonment. But if he believes his political survival depends on martyrdom, he may take that risk. Most likely path. We are progressing towards Scenario 2 with elements of Scenario 3. Trump will escalate his rhetoric while fighting procedurally. He will use the impeachment as proof of a rigged system. He will raise funds from anger. But behind the scenes, his legal team will quietly negotiate. They will try to protect offshore assets. They will try to protect family members. They will try to avoid criminal exposure. The public narrative will be defiant. Private reality will be damage control. And the Republican Party will be stuck in the middle, unable to defend him, unable to abandon him, slowly bleeding support from both flanks. This isn't just about real estate. This isn't just about Trump. This is about whether the American legal system can hold powerful people accountable and whether it can do so without destroying itself in the process. Because the Supreme Court just set a precedent. If systematic fraud justifies corporate dissolution, what else does it justify? Political corruption? Foreign influence operations? Campaign finance violations? The tool has been created. The question is who will wield it? Democratic prosecutors could look at this ruling and see a green light. Republican-controlled states could use it to target progressive organizations. Activist judges could apply it to industries they oppose. The dissolution standard could become a legal nuclear weapon that both parties aim at each other, using it until the entire corporate and political landscape is a crater. And that is the existential risk, not Trump losing his businesses, but the precedent triggering a cycle of retaliatory legal warfare that makes governance impossible. We are watching the republic's stress test. Can the rule of law function in a hyper-polarized environment? Can institutions make tough decisions without triggering civil unrest? Can America survive by holding its most powerful figures accountable? The next 90 days will answer these questions, and the answer will determine whether this is the beginning of institutional renewal or the beginning of systemic collapse. This is a clash of law, power, and legitimacy, and there is no historical roadmap for what happens next. As we enter Tuesday morning, watch for 3 critical developments. Watch for the trustee appointment. The court will designate a specific person or firm to manage the dissolution. That person's identity matters. If it's a respected former federal prosecutor, it signals professionalism. If it's a partisan figure, it signals war. Watch for Trump's first public statement. If he calls for calm and pledges to fight through legal channels, we remain in Scenario 2. If he declares the court illegitimate and calls for resistance, we enter Scenario 3. The tone of that statement will determine whether this remains a legal crisis or escalates into a political explosion. Watch the Republican congressional reaction. If senior Republicans defend the court's authority, Trump will be isolated. If they attack the decision and demand intervention, the party will split in the public eye. This reaction will come within 48 hours, and it will define the 2026 midterm election battlefield. But most importantly, watch the financial markets when they open Tuesday morning. If institutional investors are selling Trump-related assets, it shows Wall Street believes this is real and irreversible. If major law firms are advising clients to reassess their corporate structures, it shows precedent is being taken seriously. And if federal prosecutors in other jurisdictions start citing this decision in their own cases, it shows the tool has been deployed. Subscribe now. Turn on notifications. Because when the first asset sale is announced, when the first Trump property is put up for auction to the highest bidder, the reality of the impeachment becomes undeniable. Share this video. Send it to anyone who thinks this is just another legal headline. Because this is not noise. This is the sound of the system recalibrating its power. The Supreme Court just drew a line. And that line doesn't just run through Trump Tower. It runs through the entire American power structure. History isn't being written. History is being rewritten. And the first draft is being finalized in real time. The empire is under siege. The walls have been breached. And this time, there are no cavalry coming to the rescue.